Good afternoon or good morning, everyone. Welcome to the American Tax Policy Institute's webinar. I am Bridget Crawford. I am the president of ATPI, and we have a fantastic program for you today. I will turn it over to our chair and moderator, Ellen April. Ellen.
Okay. Do you need me to share the PowerPoints?
I'll get that going if you go ahead and start.
Okay. So I am Ellen April. I am a member of the ATPI board. I am currently a senior scholar in residence at the Lowell Milken Center for Philanthropy and Nonprofits at UCLA and emerita at LMU Loyola Law School. I am delighted first to thank Bridget for all that she did in helping us to organize this panel and get it together. Couldn't have done it without her. The other panelists who will be speaking with me will be Phil Hackney from the University of Pittsburgh Law School, Megan Brackney from Castellanets LLP, Brandon DeBoat from the Tax Law Center at NYU. Slide.
I'm working on it. If you could just keep going.
So in the meantime, let me say what we will be talking about. I will start with possible bases for revocation. Phil is going to talk about how revocation works within the IRS. Megan will talk about what happens in courts after revocation by the IRS. And Brandon will talk about some important statutory provisions about executive branch influence and confidentiality of these procedures. Okay, so I will say that I'm going to be talking about fundamental public policy under Bob Jones and substantial illegal purpose as basis for revocation. I'm not going to be talking today about particular bases for revocations for particular kinds of entities, such as educational organizations, environmental organizations, immigration, or hospitals. I guess I can't put up my slides. All right, so going ahead, for Bob Jones, fundamental public policy, which probably most of you know about, but it found that official policies of Bob Jones University and the Goldsboro Christian School violated the fundamental public policy of discrimination in education. It left the criteria for fundamental public policy enormously uncertain. Okay.
There we go.
Yeah, I need to start it.
There we go.
Okay. Now I need, oh, Bridget, you were going to move it.
So
yes.
Forward.
Okay, keep going. Okay. But what I think is very important, even though we don't know the limits of the Bob Jones case, and for the most part, the IRS has left it to discrimination in education, is that the case looked to the long-standing practice of all three branches of government. So it needed it to be both long-standing and from all three branches of government to conclude that schools discriminating against Black students did not qualify for exemption. Next slide, please. So the majority wrote that since 1954, so that's some 30 years before this decision, Brown v. Board, since Brown v. Board, every pronouncement of the court and myriad acts of Congress and executive orders, back please, attest to a firm national policy to prohibit racial segregation and discrimination in public education. And the opinion also stated a declaration that a given institution is not charitable should be made only where there can be no doubt that the activity involved is contrary to fundamental public policy. So that brings us to today. So can an administration's new policy towards DEI and a Supreme Court new interpretation of law, so that's Students for Fair Admissions, and the new policy is in executive orders and pronouncements from the Education Department, can that meet the Bob Jones standard? I think not. Public policy is different from fundamental public policy. I would get calls after every change in administration saying, oh, the State Department has a new position. Does that mean it violates fundamental public policy? And I would say no. Public policy are all actions by governmental bodies to address societal issues. They change with new administrations. We expect that. But fundamental public policy has to reflect core values. Now, if reconsideration of Bob Jones were to reach the Supreme Court, I have no complete prediction on what it would say. It could say the case was wrong, it should be Congress. It could say that we need to interpret discrimination very broadly from the language in Bob Jones. It's a Justice Berger opinion. It always has very broad language that sometimes can be very hard to apply to particular issues. The other, I think, general possible basis for revocation, and from giving a bunch of talks, I know how concerning this is to many, many different nonprofit tax-exempt organizations, is DEI as a substantial illegal purpose. So most authorities involving substantial legal purpose have involved criminal activity. Indeed, one of the key CPE texts, although not official authority, says the government has an interest in not subsidizing criminal activity. Oh my, surprise. Question is activity versus purpose, substantiality or not. And the authorities and the guidance do say that you can look to activity to try to decide purpose. And it says it must be considered quantitatively as well as qualitatively, time and attention to the illegal activity, and the qualitative focuses on the seriousness of the illegality involved. Some few institutions may feel that in order to survive, they should even go to court under cypre and change a purpose that is potentially illegal. I don't think many will do that, but I do want to point out that that is a possibility that an entity could pursue, as well as other arguments. So the other sense of arguments is it illegal or not for a charity to pursue remedial discrimination? And Roger Collinvo has a wonderful article on this coming out in Yale Law Journal. It is okay for a nonprofit to be partisan, long as it is not for campaign intervention for elected candidates. I do want to mention that I'm talking now about current law. There is some possibility that Phil will talk about changes on the IRS position on what is law for exemption under DEI. And I always like to come back to this line, sorry, from Justice Powell and Bob Jones, that the provision of tax exemptions to nonprofit groups is one indispensable means of limiting the influence of governmental orthodoxy in important areas of community life. So there are First Amendment arguments as well. Bill, you're muted. Okay.
Yeah, thank you, Ellen. Obviously, in this environment, I recognize many are worried about losing their exempt status. I've been getting calls from congressmen and organizations and just all over the place. Everybody has been very worried over the past 2 months in particular about losing their status. The orgs rumored to be under the chopping block that I've heard includes schools that continue to use race in decision making in any way, scholarships, admission, jobs. Environmental groups have been concerned, immigrants' rights groups, major universities. So there's a lot of concern and worry out there in terms of the impact. So what I want to talk about is what does that mean? What policies and procedures are in place to protect these organizations? And what would the IRS need to do to go about doing this? So what is it that we hear the term revocation? What is it that the IRS would revoke? And I have that essentially here on the slide, right? It's upon formation, right? A charitable nonprofit corporation files a Form 1023 to be recognized as a charitable organization under 501c3. And the letter that you receive is effectively a private letter ruling, which is a tax system that's used not just for exempt organizations, but used across the board within the IRS. But it's a determination letter because the IRS makes a determination that your organization, based on the facts that you have presented to them, is organized and operated exclusively for exempt purposes, for charitable purposes listed in 501c3. In fact, Section 508 requires a charity file a notice to be so recognized, so you have to go through this process in most instances. There are a few exceptions out there. And as it says, a positive ruling determines that the charity is organized and operated exclusively for charitable purposes. Keep that term in mind because we're going to come back to that. That's a really fundamental aspect of the law. What does exclusively mean and what does organized and operated mean? Because that's the operational test is what the IRS has to find that you failed to meet in most instances. There are a few other ways as well, but most of this is going to be, I believe, under the operational test. So a revocation is a revocation of the letter that you received initially. The IRS is pulling that letter back and saying you no longer can rely upon that letter. When you receive these letters, only the organization involved can rely upon it and gets to rely upon that into the future. So what would the IRS need to do to legitimately apply? And I'm going to talk about a little bit before I talk about this slide, and it's fine to go to the slide. But this is an aspect that Ellen was mentioning, which is, let's say there are precedents, which indeed there are, that make it legitimate to provide DEI type operations, eliminate discrimination. Eliminating discrimination is one of the purposes that are listed in the regulations, and you can find it throughout revenue rulings and so on. There's plenty of guidance protecting these types of actions that schools have long done. What would the IRS have to do in order to change those rules? They're going to have to meet the APA, the Administrative Procedures Act. They're going to have to issue notice that, hey, we believe that the rules are wrong. Students for Fair Admissions changed the law with respect to this area. I don't believe that to be true. It's a very narrow ruling regarding admitting students and has nothing to do with charitable status. But they could make the argument that Students for Fair Admissions has changed the rules in some way that changed the rules also with respect to charitable status under 501c3. They would have to issue notice and allow folks to provide comment to that. After providing appropriate time for folks to comment on that ruling, they would then issue a final rule. Now, that can be a regulation. It might be that they do this as a revenue procedure or revenue ruling. I don't know what they would do it as, but I do firmly believe they have to make that step before applying these things. Theoretically, you might be able to get away on the legality end, but even there, I think they've got a hard time coming down this path. So I don't think they can just summarily revoke, but let's talk about that. When can the IRS revoke one of these letter rulings, this determination letter that you received? So the IRS issues rev procs every year, and the current one that we're under is Revenue Procedure 2025-5. Section 12 goes to the issue of when can the IRS revoke a letter ruling. It's a little less clear in terms of the procedures that the IRS needs to follow than I'd like, but under this system, there are procedures and processes, and there are a few other places I'm going to mention in the next slide. But here, these are the 6 items where the IRS has long stated we can revoke one of these letter rulings. And I think this is the section that folks in the administration who have an interest in revoking these in the most immediate way are looking to. So the first one says, by a notice to a taxpayer to whom the determination letter was issued, which could sound like they can just summarily do this. It could be done by enactment of legislation or ratification of a treaty, by decision of the Supreme Court of the United States. And I'm sure some of them are looking at that right there, by a decision of the Supreme Court of the United States, and believing that they can argue that Students for Fair Admissions means many of these organizations just lost their status as a matter of course. I don't believe that to be true, and I'll explain some of the reasons for why I think that's wrong. Additionally, it can happen by issuance of temporary and final regulations, revenue ruling or procedure, etc. Why is this not true? Let's go to the next slide. So, first of all, and this is not even on the slide, but the IRS, to make a new determination, and it really will have to make a new determination here. It cannot just simply come in here because it needs factual information. There's a standard, and that standard regarding whether an organization is organized and operated exclusively for charitable purposes is based on all the facts and circumstances. So the IRS needs to know, let's just put it as Harvard, because that's been one of the ones that President Trump has explicitly called out. If it's Harvard, they would literally have to go in and examine every aspect of that organization, have a full understanding, because they need to be able to argue that Harvard is, one possibility was that they have a substantial non-exempt purpose. That's a pretty high bar to meet for the IRS. If they just have one little aspect out of accord, that's not enough to get the IRS over that hoop of using all the facts and circumstances. And somebody just asked, can they just do it on an executive order? No. Executive order is not the law. Executive order is just a pronouncement by the president. The executive orders, they are not the law. I have this in a mantra. It's almost a Buddhist chant for me now. I tell them that all the time. I see that. Can you tell them that? Anyway, so the IRS, according to the revenue procedure, according to their IRM, the Internal Revenue Manual, and according to their regulation 601-201, the IRS needs to go through, in effect, and conduct an examination. This is what is colloquially known as an audit. 7602 governs how that gets carried out. And the audit is essentially of the tax information return that they've filed, the Form 990, and the actions of the organization for the taxable years involved, because we're thinking about the taxable years involved. They're trying to go back before years of Students for Fair Admissions. These ideas make no sense. It's incoherent as an idea. So what the IRS first would do, after actually conducting an examination, is issue a proposed revocation letter, right? You can't just summarily remove it. The IRS procedures indicate that the IRS is supposed to propose that, and that proposed revocation letter contains information to the organization, letting them know upon the basis of which they have made that determination. And the organization can choose to seek a protest and appeal the decision within the IRS Office of Appeals. The revocation is not done yet. The revocation has not taken place at this point. The IRS once the organization gets that letter, they have 30 days to challenge it in front of the IRS Office of Appeals. And the IRS Office of Appeals will then go through a whole nother process of examining that. Once the IRS Office of Appeals has examined that question, um, a and the IRS can at that point revoke the organization's status. So let me think about if I want to get anything in here as well. Again, I really encourage you to realize it's a substantial non-exempt purpose that the IRS would be revoking upon. The regulations actually say they have to be primarily operated for an exempt purpose. Um, Getting to that level is a lot. I would have a hard time arguing this. The other part to this to realize, and Megan's going to talk about this part in a minute, is if the IRS does not go through this process, the tax court, when you challenge it, or the district court, wherever you challenge it, should find it problematic because the IRS hasn't gone through the process to determine that this organization is not properly so operated. I want to throw in one more piece because some of the revocation discussion has been on the idea of is an organization involved in terrorism in some sense. And there have been several bills that Congress has introduced but not passed through all the way through the Senate. HR 9495 last year and in the revocation bill related to 501p. So folks are worried. But under Section 501p, the Secretary of the Treasury has the authority using its OFAC to designate an organization as a terrorist organization. Executive Order 13223 gives the Secretary of the Treasury a certain amount of power to go in and designate these organizations that they're connected with terrorism in some way. It has not been used very much, although just the other day, organizations outside the US were so identified. There were 5 individuals and 5 organizations that got so identified under 501p, which are the first that I've seen in some time. The Office of Homeland Security also has issued an investigation into about 200 organizations involved with immigration rights, challenging them. So there's a number of things rolling around in this space. That would be a much larger issue if they start going down the 501p train. I'm not thinking that one is as much in the mix. It's a possible one. I don't see it with most of the organizations we're talking about, but it's something to watch. The independence of the sector is really under attack. So I'm going to go ahead and turn it over to Megan to keep us.
Let me just add,
Go ahead.
we got a question about the report of Treasury considering to issue revenue procedures. And you mentioned it, but let me come back and emphasize it. We are, as a group, I think, pretty convinced that if Treasury did try to do that through revenue procedures under current case law, the courts would say, we're sorry, that has the force of law. You have to do it through notice and comment. And the closest, a very close analogy to that is when they changed Schedule B to exclude non-charitable organizations. Actually, the then governor of Montana brought suit because he had standing. And the court said, has to go through notice and comment. You can call it a revenue procedure, but because it is a legislative rule, the Administrative Procedure Act has to apply. I would see the same thing happening here. Do you agree, Phil?
I fully agree. I think they've got to go through the APA. I don't see how the courts would, with the system that they have constructed, find anything other than this would effectively have been some sort of a question that they really needed to issue it upon. And the IRS has long operated under these rules. And I think that includes the IRS rules and procedures regarding this. If they go start yanking immediately, I think they've got to go through the APA as well. Should we mention Z Street as well?
Yes, please.
Yeah. So one other precedent out there that I think is really important is a precedent under the Obama administration where the IRS was accused of establishing a policy against organizations having policies inconsistent with President Obama's opinions regarding Israel. In this particular case, an agent said, hey, we're applying more strict scrutiny to your organization because your organization is out of sync with President Obama regarding how Israel should be treated. The organization, this was told to the attorney, the organization challenged that in district court, and the court found, even though there's an Anti-Injunction Act, Declaratory Judgment Act, that prohibits, in most instances, you challenging the IRS before they've come to a final determination, they found that the organization had a right to do this because there was no other course of action that they had associated with unconstitutional discriminatory action. So one of the possibilities, if folks start getting wind of the IRS is acting in some way that violates some fundamental constitutional right, there might be opportunities to challenge these even before you get to any kind of final determination.
And let me add one other issue related to this. Many bases for charitable tax-exempt organizations have been through revenue rulings. That did not go through notice and comment. Environmental groups in particular, I would point to at this moment. But again, under current case law, if the IRS tried to change those rules, again, I know Phil and I have talked about it and agree that it would have to also be done through notice and comment in order to satisfy.
Yep.
Even though they were issued under revenue rulings, the law is different now.
Yeah, no, I think that it's I can't imagine a world in which they don't go through that process, given the long practice of the IRS approving these organizations year after year after year, and issuing guidance.
Megan.
All right, thank you. So I'm going to talk briefly about declaratory judgment actions. And I thought it was helpful to start with this slide, just to remind everyone that the ability to get judicial review of the IRS's determination of revocation is by an act of Congress. And so, like part of the theme of our panel, this can't be taken away by executive order, by a change in a reg or a revenue procedure. Taxpayers have a right to this relief. Next slide. All right, so moving to the next slide, we have how do you do it? The first thing that the charitable organization needs to do is to go through the IRS appeals process, which Phil just talked about. There is a requirement to exhaust administrative remedies prior to filing suit. It's also important just to note, as we're going to get to a slide with the tax court rules in a second, that it's very beneficial to the exempt organization to develop the administrative record as fully as possible during both the exam and the appeals process. Because although there may be some opportunity to submit additional evidence later, it might be limited and challenging. And so you want to fully develop as much as you can so that you are ready to go to court. So as we can see in the slide, this is under section 7428, and the organization has 90 days from the date of the determination to file the declaratory judgment action. So if we go to the next slide, there's a concurrent choice of forum here. It's really up to the taxpayer where they want to go. District courts, tax court, or court of federal claim are all available. We typically see these cases coming up through the tax court for various reasons, probably because the tax court is the most user-friendly of courts, in my opinion. And they also have subject matter expertise because they're the main court that sees these cases. But you're not limited to the tax court if for some reason your exempt org wants to pursue the action in a different court. And of course, it's not the final determination. These actions can go all the way up to the Supreme Court if that is what's appropriate. Go to the next slide. So I threw up here tax court rule 211G just because to alert folks, if you are going to be handling declaratory judgment actions in tax court, to know that there are special procedures that apply. The procedures that apply to the bread and butter of the tax court deficiency procedures may not be give you the right rules. So you need to read on into the tax court rules to see what specifically needs to be included in your petition. And so that is outlined here as well as on the next slide. So we can move on to that. I will also note, because I referenced the administrative record a minute ago, if you look at tax court rule 217, which is not in the slides, but you can find it easily on the tax court website, that's where it talks about the administrative record. And what the tax court rule 217 says is if the parties agree that the administrative record contains all of the necessary factual information for the tax court to make a determination, then it'll be made on that basis. So again, it's giving a little wiggle room if there's an issue, but it definitely is indicating to petitioners to, to try to develop your administrative record as fully as possible, as well as the IRS. So we can go to the next slide. And the burden of proof is important here. And one of the things Phil just mentioned is if, the IRS takes some action without fully, developing the factual basis for the revocation during an examination or in some other fashion, that, the court might not look too kindly on that. And I tend to agree on that, but I also do want to emphasize here that the burden of proof ultimately is on the exempt organization. And so it's not going to be a complete defense to revocation just to come in and say, well, the IRS didn't really give a coherent reason for its action. The exempt organization is still going to have to show that it's entitled to tax exempt status, meeting all of the factors there, and that the IRS's determination was incorrect in some way. And so that is important to remember. You're coming in with the burden of proof. And again, emphasizing that you want a good factual record to support your burden. We can go to the next slide. So there is this, and this I think is part of this that I guess is kind of the most tricky or complicated, which is retroactive revocations. And so it is possible for the IRS to make a revocation that applies retroactively. And we'll talk in a minute as to sort of like what the consequence of that might be. But we list here some of the reasons that there might be a retroactive revocation, and they all make sense and I think are fairly intuitive. But the IRS, as we note here on the bottom, except in certain cases of fraud, will explain the grounds for why the determination is being revoked or modified and why that is being done retroactively. So this will be also something that if you challenge the determination in the court, you can challenge, you wanted to challenge both things, both the revocation and also the revocation retroactively, so that you don't have some of the consequences of that. So we can go to the next slide. Okay, so the effective date rules are a little bit complicated, and so if you have a retroactive revocation, it basically depends on the facts and the reason for the revocation. And so if there was, let's say, a material change and that was the reason for the retroactive revocation, it's going to take effect as of the date of the material change. And so again, I don't want to spend our time going through these rules, which are a little bit technical, but it is important also, if you're handling a case which has a retroactive revocation, is to pay close attention to what the date is and why it is that date, because again, that may be another basis to challenge it if the IRS is being very aggressive and pulling the status retroactively at a very early date. So we can go to the next slide. This is a question that we seem to be getting a lot. I think people are just curious about it, which is like, well, then what happens, right? Like, let's say I'm contributing to a charitable organization and they lose their status. Like, do I still get my deduction as an individual if I'm a contributor? Is this organization still going to be able to operate? Is the government, going to be able to take other actions? And so the rule generally is, favorable to taxpayers for most individuals, which is if that even while the case is being reviewed, the organizations can still make contributions. They're limited. As you can see there, they may not exceed $1,000 and still be able to claim charitable deductions during this time period. And we can go to the next slide. I think that is the next topic, but before we get on to that, I did want to say one more thing about revocations, which is there is a limitation on when the individual can no longer take a charitable deduction if there's been a revocation, and that is for any donations that are made after the date that the notification of revocation is made public. And so if you look at irs.gov, there's a list of all of the exempt organizations whose status has been revoked, either through some sort of process like we're talking about here today, or automatic revocation, which would be for things like not filing Forms 990 for more than 3 years in a row. And so that's there, and it's there for public notice. A very careful taxpayer and tax return preparer would check that, I guess, before they file their tax returns every year. I don't know how much enforcement there is on that, but that is something that if you are a major donor, you might want to check into before you file returns. But it would be a pretty unusual situation, I think, for someone to get caught up in that. But I'm going to, I don't think
I
there's
have a question for you,
Okay.
Megan.
Yes.
Since you are our actual practitioner on this call, one of the things I learned recently, which I hadn't known before, that if there is a technical advice memorandum on point, that can prevent going to the Independent Office of Tax Appeals. Have you ever seen that in your practice?
No, not in this context. I mean, there are certainly issues that are, and then maybe this is what you're getting at, which are coordinated issues. And so the appeals office is deprived of sort of the ability to consider a particular issue. Like, for instance, one thing that we're seeing is there's an issue, and this is very far afield for your audience, but as to whether or not the IRS has the authority to enforce and collect certain foreign information return penalties, right? And that's being litigated. IRS appeals is really not like permitted to consider that while they're considering hazards of litigation, you know, or they may not be. So that's an example of a situation where they've got a directive that says, like, we're not going to consider this type of question in terms of evaluating hazards. And then there are also situations where, for policy reasons, the IRS wants a uniform outcome in certain kinds of cases. And those tend to be in like promoted tax shelter cases and other types of things where there are similar issues across the board. And in those cases, the appeals officers may not have any discretion to settle or have very limited discretion. So I don't know if that's what you're getting at, or.
Phil, do you have a thought on the TAM issue?
On which issue? Sorry.
The technical advice memorandum issue.
Oh yeah, so they've changed.
We searched for this.
Yeah, we searched this down, and there are certain instances where you can't go to appeal if you have gotten a technical advice memorandum under exam. So you're on exam, when you're under an exam, an audit, and you disagree with the Office of Chief Counsel advice that they're getting, you can challenge that as a taxpayer. If you're disagreeing with the agent, you can challenge that and request a technical advice memorandum. If you get that technical advice memorandum, the new regs seem to suggest that you can no longer go to the IRS Office of Appeals. So that's the weird little glitch in
Yeah,
that.
thank you for clarifying that. I didn't realize that, and I have not seen that yet. But
we had to really track that down. It took
a while.
Okay, then I won't feel so bad. But I will say, I went off on a long tangent there, but I don't think it's totally irrelevant in the sense that one of the things that I guess could happen, and if going forward, is there's always the possibility, right, if we're seeing common issues or certain types of legal challenges to the IRS's action, they're going to court, that may prevent appeals from, fully considering or fully being able to settle certain matters, and it may require taxpayers to go to court. That happens in all kinds of situations. And here, if what we expect to happen happens, which is we have a lot of cases all at once where there are revocations being considered by the courts, we may have less appeals ability to resolve those cases. But it
We
remains
have
to be
some
seen.
questions on this. Maybe Bridget will enable us to
I pulled them up.
the actual regulation.
Yeah, I'd note that there's a comment, which is that someone actually does have an IRS issued a TAM during their audit, and
great.
they're allowing them to still file a protest, and that's
Okay.
pending in appeals now. And maybe this is just with a coordinated issue. It was just a really recent reg that was adopted, and somebody was talking about it at the last ABA tax meeting, and so I saw the reg. So anyway, we'll see where that goes. I don't know where that's going.
Let me also say there are several very good questions in the Q&A as well as the chats. We will talk about them. I will raise them after we have all our speakers. And I think it is Brandon's turn.
All right, thanks so much. I'm going to cover the tax code's protections against weaponization and protection of taxpayer information. In a sense, it's unfortunate to even have to cover these topics as part of this discussion of tax exempt status, but I'm happy to be here and discuss them. Starting with political interference, Congress has acted to try to insulate the IRS's enforcement from political influence and targeting. In the 1990s, previously unheard tapes of President Nixon planning to use the IRS to go after his enemies and not his friends were released, which sparked criticism. And around the same time, a bipartisan commission focused on IRS independence from political pressure as important to maintaining confidence in the tax system. And in the wake of these developments, Congress acted on an overwhelmingly bipartisan basis to enact Section 7217. Section 7217 makes it unlawful for a number of officials, including the president, the vice president, their staffs, as well as any cabinet level official other than the Attorney General, so that includes the Secretary of the Treasury, to interfere in an audit or investigation of a particular taxpayer or to request one. And this covers both indirect and direct interference. So, for example, if the president or a White House official asks a third party to request that the IRS change an audit approach to an audit, that would be covered. Section 7217 has a mandatory reporting provision. So any prohibited request must be reported to the Treasury Inspector General for Tax Administration. And violations carry serious criminal penalties. Either making a prohibited request or failing to report it can be punished by up to 5 years imprisonment and a fine of up to $5,000. Next slide, please. A related provision that existed before 7217 protects against interference and intimidation of IRS officers and employees. This is Section 7212, which makes it a crime to corruptly, by force or by threat of force, attempt to impede or obstruct the administration of the tax code. This provision is designed so that IRS officials can do their job without fear or favor by outlawing interference with IRS employees, including intimidation or harassment while they're performing their duties. It also carries serious criminal penalties, including up to 3 years imprisonment or slightly less in the case of only a threat of force. Turning to confidentiality protections, so there are stringent protections that apply to the very sensitive information that's needed and collected as part of tax administration. Section 6103 is the foundational statute here. It was enacted in the 1970s on an overwhelmingly bipartisan basis after the Watergate hearings and other hearings and developments that brought to the forefront concerns about having the president control who had access to tax information and the potential impact that could have on voluntary compliance. So Section 6103 provides a baseline rule that taxpayer returns and return information shall be confidential unless otherwise authorized by the statute. Congress has provided a variety of specific exceptions for sharing certain types of IRS data and has done so on a repeated basis when it determined data sharing should be expanded, but those are specified in the statute. And when data is shared outside the IRS, the protections that apply to the IRS also apply to other agencies. So return information under 6103 is defined very broadly, covering virtually any information collected by the IRS regarding a person's tax liability. It includes, for example, whether a return is being, has been in the past, or will be examined, or subject to other investigation or processing. The tax code protects against both unlawful disclosure as well as inspection or browsing of returns, and both of those are also defined very broadly. And we've seen a lot of actions, statements, and efforts at data sharing already during the current administration that raise serious concerns about violations of these laws. Next slide, please. Finally, to touch on the potential consequences for and remedies for violations, on the civil side, there is a cause of action available to taxpayers whose return or return information is knowingly or negligently disclosed or inspected without authorization, provided by Section 7431. Damages start at a minimum of $1,000 for each act of inspection or disclosure, and can be higher in the cases with higher actual damages or punitive damages. The U.S. will be the defendant if the violator is a federal officer or employee. Otherwise, it's the individual who's on the hook. And there's a 2-year statute of limitation from the date of discovery for the taxpayer from the disclosure or inspection. And there's a good faith defense available in the civil actions if somebody had an erroneous but good faith interpretation of 6103. And finally, there are serious criminal penalties that can apply for willful unauthorized disclosure or unauthorized inspection, up to 5 years imprisonment in the case of willful disclosure, and 1 year for willful inspection. These are generally subject to a 3-year statute of limitations. And finally, I'll note that the reconciliation bill that passed the House recently would increase the maximum penalties for willful disclosures quite substantially, underscoring the seriousness with which many members view taxpayer privacy violations. So that's a brief overview, and I'm happy to discuss any questions.
So Brandon, there was one question about 7217 reporting to TIGTA and the firing of Inspector Generals. TIGTA inspector has not been fired as far as I know. I'm still getting reports quite regularly from them, but all of these do require somebody in the administration to take the action that's required. TIGTA refers it to DOJ. DOJ would have to bring a case, but your thoughts on that?
Yeah, the acting TIGTA is still in place, and you're certainly right that there's action that needs to be taken by the person receiving the request. There's a legal obligation to report it, and then TIGTA has to make an assessment and determine how to proceed once they hear about a violation.
And as I get reminded all the time, failure to do that, there's still a pardon power in the president. So Phil, why don't you go on with the endowment tax, and then we can go back to some of the questions, but really good questions I am seeing.
Yeah, there's some great questions. So I'm going to do this fairly quick, I think, because I'd like to get us to the questions. I think they're important. So in 2017, in the 2017 Tax Act, Congress implemented for the first time an endowment tax on universities. In 23, it was like 53 universities. I think it was 58 in 22. So some universities managed to figure out how to get out of it. They collected about $244 million from these institutions, 1.4% rate on groups that have an endowment to student ratio of $500,000 or more. today, I mean, in the reconciliation bill, in the 25 reconciliation bill, they have increased that rate substantially depending upon the amount, up to 21%, which is the corporate rate. They're essentially treating a university as a private corporation without abilities to offset losses. So you've got a net investment income tax that is harsher, I think. I haven't gone through that completely, but I'm pretty sure it ends up being harsher to universities than it actually is to regular corporations who can offset.
And it's a cliff, right? It isn't that.
Yeah, it's just all of a sudden you're in. There are 5 universities that are affected by the 21% rate. It's Harvard, Yale, Stanford, Princeton, and MIT. There's also an exclusion for certain religious universities. I've heard it suggested that that might have been designed for Notre Dame. I'm terribly troubled by these, primarily from an independence perspective. I am someone who is definitely sympathetic to an argument that wealth has a particular effect in these spaces. But when so many attacks are being made onto the civil society organizations like Harvard, taking their ability to be independent away, I think is of significant concern. So I'm kind of concerned about this. We'll see where it goes. But I think it's a real attack on the independence. And it's odd to do it to universities and not, say, hospitals or other parts of the sector. It seems to be directed with some animus towards these institutions rather than being a neutral approach to these questions. It certainly is striking at an aspect that people have reasonable concern about elite universities having a particular impact, but I don't see these bills being directed towards getting more money to students in any kind of systematic way, which concerns me about this system. I think it's probably best to go on and answer some of these questions. So because there's some really good ones, both in the chat, Ellen, and in the.
So I'm going to do the chat first because I have that up, and then I'll go to the Q&A. So someone asked a really good question about the success rate of appealing nonprofit exempt org revocations. Phil and I were able to find data on the number of revocations that the IRS has done. And there was a very recent article how they have plummeted recently. I don't know, Megan, is there a way to find out how successful in appeals of revocations are under the Declaratory Judgment Act? I confess I haven't researched that.
I don't think that those statistics are available, but on that point, and also on the point of like what's coming up in enforcement, there was a TIGTA report, I think it was TIGTA, or it may have been from another source recently, about the loss of and reduction in force and the retirements and whatnot that have happened since the administration changed, and that the tax exempt and government organizations group was one of the hardest hit, with somewhere north of 30% of a loss in staff. And so it's an odd situation that we're in right now, where the audits for exempt orgs were very historic low rates last year. There's been another big downturn in personnel in that group. And yet here we are talking about it as if like all of these audits are imminent. I don't know what to make of that. It's like all the pieces aren't coming together. What the administration is saying publicly and in the news versus like what's happening on the ground don't match up. Will that change? Will there be resources put into exempt org enforcement? Where will there be hiring there? Will that become an enforcement priority? I have no idea. But based on sort of the rhetoric, at least, of the administration, it seems like that's a possible and maybe even probable outcome of where the IRS is going to take this.
I have some thoughts on it. Like when I was at the IRS 2006 to 2011 in chief counsel doing this work, we won when I was there if we challenged, but it was rare to actually have a challenge that went to court. And there's an aspect of being in the office of chief counsel, which is there is a directive that we're trying to get the law right. And I took that as a very serious thing. If I saw a case come forward where they were trying to summarily revoke and I didn't have any information, I would tell them that we're not going to take the case, that we wouldn't bring this case forward. So I think we're in a different world where the information regarding how successful the IRS might have been in past, the IRS does sometimes lose. I mean, I saw some when we lost when I was there, but generally we'd win them, but it would win them because we were taking generally good cases. I know there might be disagreement on the outside, but
No,
but
you have the
IRS
luxury
doesn't
of
have the
choosing the
staff to do this,
case, right?
Yeah.
Because you can always just change the direction.
Yeah, you're
Um,
gonna give up cases that you're gonna lose.
Mhm.
So questions in the Q&A. Let me do the ones I think are short first. Can the IRS revoke for failure to comply with state charitable registration laws? No. That would have to be done by the state attorney general. And we probably get First Amendment challenges to doing that. Megan, if you could go back to the issue about foundation grants over 1,000 after final revocation determination letter. How does that work?
Yeah, let me, could we, Bridget, is it possible to put that slide back up?
I will try.
Okay. Trying to find what number it is.
Well, I can probably tell you that.
Okay, sorry about that. Yeah, I just wanted to be able to refer to that. I don't know if we put
It's
that on there.
slide 20.
Okay.
Right, so, okay, thank you. Right, so
You had it a minute ago.
right. No, I am not sure, and I don't want to say something incorrect. And so I refer you to the slide and I will take a look at that and can follow up on that question later.
Thank you. So another really good question that we have only a few minutes about how much weight after Loper right given to a revenue procedure or a new regulation. So I think the revenue procedure, new revenue procedure would be the same as a regulation under current law. They would treat it as a legislative rule having to follow the APA. How much under Loper Bright, whether a court could say we don't have to defer, depends how specific the regulation is. So we're not sure about 7805 regs. Ones that are specific enough may survive Loper Bright. I have a little piece on that and another one coming out. Other thoughts on that? So, okay, we've got to go really quickly. What about exclusive charitable purpose versus primary purpose? Where's the substantial in the regs? Always an issue. We have Better Business Bureau as well. I've always taken the position that once UBIT got enacted, it couldn't be exclusive activity anymore. But the regs are not as lovely as we would like. And it's possible under Loper Bright that could become an issue.
As a practical matter, I would say IRS always uses substantial non-exempt purpose when they revoke. So I focus there personally, but.
And the regs go on to that for 501c3, then go to substantial exempt purpose. Okay, judicial review. I'm looking at another question. Any more about Z Street? It was a First Amendment issue. I do think Harvard could have a First Amendment issue and therefore could try to use the Z Street case to appeal before any final revocation, but I can't speak to Harvard's strategy or thoughts.
Yeah.
Bill, anyone else on that?
Yeah, I mean, I think that one is a live issue, and I think it is something that liberal groups should be looking at under this circumstance because there is a justice, I think, in treating ideological groups the same. So I would absolutely be thinking through that process.
Okay, my clock says 9:59, and I'm told we are going to stop exactly at 10 o'clock my time. I'm the West Coast, unlike the rest of you. So I just want to again thank all of the panelists. I've been looking at this and I still learned a lot from the panelists today. And again, thanks to Bridget for her help, and thanks to all of you for joining us. If you have other questions, you can find our emails easily. I forgot to include that on the slides, but please either send them to Bridget and she'll send them on to us and we will try to respond. Again, it still says 9:59 on my clock. Thank you everybody so much.
Yeah, thank you.